Okay, students, welcome back. And in this part of lecture, students, I'm going to uh, deliver my lecture and discussing with you a topic regarding the appointment of the president, vice president of the ICJ, and duties of ICJ, and thereafter very much important topic, that is the jurisdiction of the ICJ, and further topics which are related with our today's lecture. So, students, after every 3 years, the court elects its president and vice president. The president chairs all sittings of the court, and he or she directs its work and supervises its administration. And annually, the president presents a report on the working of the ICJ to the General Assembly. And further, the president and vice president are elected by the members of the court every 3 years by the secret ballot. And the election is held on the date on which members of the court elected at a triennial election or to begin their terms of office or shortly thereafter. An absolute majority is required, and there are no conditions with regard to the nationality. The president and vice president may be re-elected, and thereafter, under the article of 31 and paragraph 2 and 3 of the statute of the court, a state party to case before the International Court of Justice which does not have a judge of its nationality, as earlier discussed, on the bench may choose a person to sit as a judge ad hoc in that specific case under the condition laid down in the article 35 to 37 of the rules of the court. Before taking up his or her duties, a judge ad hoc is required to make the same solemn declaration as an elected member of the court, and he and she does not necessarily have to have, and often does not have, the nationality of the designated state. And further, uh, the students, further, what are the duties? What are the duties of the ICJ? Like it is predecessor, PC IJ has two roles. The first is to decide disputes between states, and these are known as the contentious. These are known as contentious cases. The second role is to analyze legal questions submitted to it by the General Assembly, the Security Council, and other organizations and agencies under the United Nations. These cases are known as the advisory proceedings. So actually, these are the jurisdiction of the ICJ. So in this further further discussion, which is very much important. What are the jurisdictions? What is the jurisdiction of the ICJ? Broadly speaking, there are two kinds of the jurisdiction of the court jurisdictions. Number one, contentious jurisdiction, and number two, advisory jurisdiction. And contentious jurisdiction, that jurisdiction of the court on the basis of which the court decide any case with the consent of the parties to the case, which is called contentious jurisdiction. It is fundamental principle of the international law that without the consent of any party to a case, the same shall not be referred to the mediation or arbitration. Contentious jurisdiction is of three kinds of jurisdiction, which may be defined as number one, voluntary jurisdiction, ad hoc jurisdiction, and compulsory jurisdiction. So, voluntary jurisdiction is that the jurisdiction which the parties, by virtue of an agreement or treaty, confer on the court is called voluntary jurisdiction. In voluntary jurisdiction, the parties to a dispute give their consent for the jurisdiction of the court in advance, And ad hoc jurisdiction, that jurisdiction of the court when the parties after the occurrence of the dispute confers on the court and in which the court has no right to take up the case is said to the ad hoc jurisdiction. And third part of the jurisdiction of the contentious jurisdiction, that is the compulsory jurisdiction. Compulsory jurisdiction means that type of jurisdiction which the court enjoys without the consent of the parties. In case of the compulsory jurisdiction, the court is to be empowered to take up a case without the consent of the parties, like municipal courts, like our domestic courts. And the next jurisdiction, that is the advisory jurisdiction. Advisory jurisdiction means that the jurisdiction of the court by which it may only gives an advisory opinion on a question of law, and this does not require the consent of the party to a case. But when any international institute, General Assembly, or Security Council asks the court to give any advisory opinion on the question, this opinion is not binding on the parties. So the case may be referred by the international organization or by any organs within the scope of their activities. So there is another jurisdiction which we call the incidental jurisdiction. Is the court's first role is to judge legal dispute between the states. This constitutes a large part of its work. In the past, these cases would relate to the broader disputes, maritime delimitation, and diplomatic protection. But now cases such as human rights, environmental rights, and the responsibility of states are brought in front of the court. The court jurisdiction is a general and can consider any issue of international law. All United Nations members can bring cases of the contentious nature before the court. Non-member nations can also access the court but are subject to the certain conditions. Therefore, the court jurisdiction extends throughout the world. It must be kept in mind that the states are sovereign and they can decide how to resolve their disputes. The ICJ cannot ask sovereign state to act without them approaching the court. Therefore, the ICJ can only hear a case if both the national parties have freely consented to it. And what will be the procedure of the ICJ once they have appeared before the court? The proceedings take place in two steps. First, the states submit their arguments, evidence, and submissions in writing. Then their representatives and their lawyers present oral argument before the court. The court then begins its deliberations. These deliberations are confidential, and questions or issues of the case are decided by the judges present. On an average, deliberation lasts for 4 to 6 months. Once a decision is made, the judgment is released in the court's two official languages and reproduced in the several sealed copies. All the judgments of the court are final and without any appeal. By coming before the court of the justice on their own consent, the state parties take an oath to comply with the judgment, and such judgments are binding upon the parties. If one of the parties refuses to comply with the decision, the aggrieved party may seek recourse from the Security Council. The Security Council may then, under Article 94 of the United Nations Charter, make recommendations or decide measures on how to give effect to the judgment. So, in that context or connection, students, there's a very famous case between Pakistan and India of Kulbhushan Yadav. So, as the Pakistan or India are members of the United Nations, and automatically they become the member of the ICJ. So, India took up the case before the ICJ regarding the Kulbhushan Yadav. And in the meanwhile, court also the state court, Pakistani courts also give the decision of the death penalty to the Kulbhushan Yadav, and the state of India challenged that sentence before the ICJ, and in the meanwhile, ICJ stopped that sentence, and also direct Pakistani authorities to give the access to the Kulbhushan Yadav to the Indian authorities and their relatives as per the Vienna Convention. So the act of the ICJ regarding the stopping the sentence, that is the incidental jurisdiction, and took up the jurisdiction of that case is the contentious jurisdiction. Is the India and Pakistan both are the member state of the United Nations, and there's one a very interesting point is that when that case took up before the ICJ, there are 15 judges, including Justice Bhandari, who belongs to the India. So there is no representation from the Pakistan. So Pakistan requested, as per their statute articles of the statute, any judge can be appointed when any state requested because there is no representation. So Justice Jilani was elected as the ad hoc judge in that case. So their strength become the 16. 15 are the elected member of the ICJ, and one is the ad hoc judge, and that is the the members of the ICJ become the 16 judges. Now 16 judges are hearing on that case, which is still pending before the International Court of the Justice. As earlier we have discussed, where advisory proceedings and United Nations or any international organization can seek the help or any advice on the point of law from the ICJ. So students, that was the comprehensive or very thorough understanding of the jurisdiction, which we can understand after the reading of the decision of the ICJ. So our next topic, what are the loopholes, what is the criticism, what are the weak point of the ICJ. So students, thank you for this lecture, and our next lecture regarding the criticism, weaknesses and loopholes of the ICJ and its decision.